Welcome back. The lawyers representing 5 of the 7 suspects charged with the murder of rapper Kiernan, AKA Forbes, and his friend Tebello Tibz Motsoane have accused the state of delaying proceedings. They're presenting their closing arguments in their client's bid for bail. It's all unfolding in the Durban Magistrate's Court. Now, last month, the alleged coordinator of the murders claimed that the state only had circumstantial evidence against him.
Your presumption is everybody is able to articulate himself. If that was the position, Mr. Pillay, the investigating officer, would have stated exactly in those clear terms. That it goes back to the concern that I've raised, the generic allegations.
Yes,
it would have helped all of us if the state was able to take everybody into full confidence and tabulate. This is X, Y, Z that is outstanding. For instance, if there is an allegation of a money laundering, probably one will think of a forensic audit report. Somebody would expect perhaps the DNA to be outstanding. So under normal circumstances, it is the practice in our bail applications, Your Worship, where the state will take the court into full confidence and say, investigations are at an advanced stage, however, outstanding is the following. It doesn't help to just generically refer to the investigations as being at an advanced stage.
All right, let's get you some analysis on today's proceedings. We're joined this afternoon by legal analyst Kabelo Seabi. He joins us in Pretoria this afternoon. Kabelo, it's great to see you. Thanks very much indeed for coming on. I want to actually begin with something that I heard unfolding in court just earlier. One of the defense lawyers arguing that her client should not be prejudiced just because he has 4 cases pending against him. She says it's not the number of times you've been rounded up on a charge, but rather the number of times you have been convicted. What do you think that the magistrate will make of this?
Good afternoon. In a bail application, one must keep in mind that a bail application is not a trial. It is simply an inquiry to determine as to whether a person who is in custody should be released to stand trial while they are outside of the prison or outside of custody. Now, one of the inquiries that needs to be done is to determine as to whether this person would stand trial. And in doing that, the court has to look as to whether this person has had previous collisions with the law. So your pending cases are looked at. If you've got pending cases, the nature of the pending cases is looked at. What are the charges in the pending cases? And also the previous convictions are looked at to determine whether this person in the previous collisions with the law, what have they been convicted of? What were the sentences that they received on the previous matters?
Yeah.
So it is imperative that the court inquires into those issues.
But I suppose the question becomes, what qualifies as a collision with the law? Simply being a suspect in a matter or being convicted?
Both. That's why what I was trying to explain. If you have got pending cases, the court has to look at those pending cases, look at the nature of the offenses that are pending against the bail applicant. The court must be able to be appraised as to what is the cumulative effect of those pending charges as well. Is this person likely to commit another offense? Obviously, that's the one other consideration in bail. Is this person who's out on bail on a previous matter likely to commit further criminal offenses if they are released on bail?
Yeah.
The court must inquire into those.
Yeah. It's very interesting just watching the AKA murder trial and this bail application and the closing arguments in the I meant the Senzo Meyiwa murder trial and then the AKA and Tibz bail application. In both of these cases, the defense is arguing that the state is essentially trying to delay proceedings. In the Senzo Meyiwa murder trial, it's a case of the state saying, we are being ambushed, or of the defense saying, pardon me, that we are being ambushed by the state. They're not providing us with evidence on time. It means we don't have time to go through the evidence before our court appearance. And in fact, that was an accusation that was made in the AKA and Tibz case as well, with the defense accusing the state of trying to delay proceedings. I mean, that doesn't seem to me like something that would work in the state's favor, to purposefully try to ambush the defense or to delay proceedings.
Michelle, let me explain first that there's a difference. A bail application, as I said, it's an inquiry to determine whether a person will stand trial. It's not a trial itself. So in a bail application, the magistrate who's hearing the case is able to request that certain things be disclosed to the court in order to come to a judicious decision as to whether bail should be granted or not. So in a bail application, you can even present what would typically be what we call hearsay evidence, where the evidence is not the type of evidence that would be admissible at a trial. So in a bail application, it's more of an inquiry to determine whether the person should be released or not. In the trial, the Senzo Meyiwa trial, what I followed up this morning is that the scope of the documents that are being asked by the defense, it goes beyond what the state needed to prove its case. So in a trial, unfortunately, if the accused persons themselves are going to ask for an extended disclosure, you will have these stop-start proceedings as has happened in the Senzo Meyiwa trial, because if you look at what is being requested, these are not material that the state readily had at its disposal in order to prove what the state wants to prove.
So you're saying that, if I'm understanding you correctly, because us mere journalists, we're also trying to understand the legal system. Are you saying that the state would purposefully provide incomplete affidavits, for example, insofar as the Senzo Meyiwa murder trial is concerned, and the cell phone records that they were arguing in court?
No. I'm saying the state provided what the state needed to prove its case.
But not what the defense needs.
If the defense, during their questioning of state witnesses, they see that there is something else that they require, the state might not have needed that aspect to prove its case. So that is why, for instance, in the case of accused number 4, the counsel has asked for section 205 for phone numbers of his client, which the state apparently did not intend to use in the trial. So you will have instances where the defense itself broadens that which is required in the case, which the state did not envisage when it was planning the aspects that the state needed to prove.
No, certainly, because the state is just working to prove its own case. Yeah, that absolutely makes sense. Kabelo, if we can just shift to the AKA Tibz matter for just a moment. We know that the 5 men accused of killing AKA and Tibz, they are in the Durban Magistrate's Court. That case is ongoing. But there are also these 2 other accused that are still waiting for extradition in Eswatini.
Yes, the 2 suspects who are in Eswatini has to go through the extradition process in Eswatini. And as soon as that process has been finalized, and if the court in Eswatini directs that they should be extradited, the Ministry of Justice in Eswatini will then hand over those suspects to the South African authorities. Those suspects will be brought to South Africa and eventually will be added as co-accused in this case that is unfolding in Durban.
Yeah. I'm crisscrossing from one case to another, but in the Senzo Meyiwa murder trial, Kabelo, it's now postponed until the 13th of May. This follows several other postponements over the years. It follows the trial within a trial. Does it feel to you that the case is dragging?
The case would seem to be dragging, but one must understand that there is a duty on the court to allow the defense to be allowed all opportunity within reason, obviously, to prepare their case, to be able to ventilate their case before the court. So that is what is happening. The judge, although he seems a little bit perturbed that the matter is going slowly, always he is prepared to adjourn the matter in order to allow the defense all opportunity under reason to be prepared and to be able to ventilate their case fully before the court.
Kabelo Seabi, let me thank you for your time. Thanks for giving us some insight into how these things unfold. Kabelo is a legal analyst as we continue to track both of these they're quite high-profile cases that are unfolding in the Durban Magistrate's Court and, of course, in the High Court in Pretoria.